morning to one and all present here. As you all are aware, we are gathered here for the National Workshop on Intellectual Property Rights by the Internal Quality Assurance Cell, Mihirboj PG College, Dadri. Before proceeding further, I, Samasing Meena, Co-Coordinator Internal Quality Assurance Cell, would like to take this opportunity to welcome you all to the workshop. Moving ahead, with the permission of our respected principal sir, let me give you a brief introduction of the topic. किसी भी व्यक्ति का अपनी खोज या निर्माण के साथ एक गहरा जुड़ाव या लगाव होता है और संभवतः यही वह प्रेरणा स्रोत है जो उसे नित नए खोजों के लिए, नए आविष्कारों के लिए प्रेरित करता है या नवीन ऊर्जा प्रदान करता है। लेकिन इसके साथ ही यह भी सत्य है कि वह व्यक्ति यह अपेक्षा रखता है कि उसकी उपलब्धियों को उसके नाम का वैधानिक परिचय प्राप्त हो। अब सवाल उठता है कि व्यक्ति की किन उपलब्धियों को वैधानिक संरक्षण प्राप्त हो या किन चीज़ों को हम बौद्धिक संपदा इंटेलेक्चुअल प्रॉपर्टी कहते हैं। The World Intellectual Property Organization defines intellectual property as creations of the human mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. In other words, any form of creation of human intellect is called intellectual property, be it a book, a painting, a logo, a name of a company or a product, or simply an idea. Most of the participants here must have heard of the terms copyrights, trademarks, patents, GI tags, etc. What are these? These are some of the rights given to the creators of intellectual property. The creators or inventors are given exclusive rights over their intellectual property with certain terms and conditions which may differ from country to country. These rights are generally ensured through country-specific laws. In India also, we have many such laws and rules to protect intellectual property rights. We also have the National Intellectual Property Rights Policy that was enacted in 2016. The clarion call for this policy is Creative India, Innovative India. So the question arises, why so much focus on the protection of intellectual property rights? In the 21st century, it has become easier to copy or steal the ideas and works of others with the ever-increasing uses of technology in all the spheres of life. In this context, it becomes necessary for all of us to have some basic information, basic knowledge about intellectual property and the rights associated with it. That is what we aspire to do in today's workshop. May I now invite Dr. Priyanka Yadav, who is coordinator of Internal Quality Assurance Cell, to kindly welcome our respected principal sir and introduce the spokesperson for the first session.
Thank you very much, Samay sir. So, let me feel pride in introducing a very dynamic, well-versed in all the spheres of academic and administrative duties, versatile, energetic, dedicated, and a good motivator, a guide. He is behind the various quality initiatives taking place in our college, and this program is one among them. IQAC would not have done this program without his support and guidance. There's a lot to learn from him. Mihirboj PG Parivar feel blessed to have principal like him. Please put your hands together for Professor Dr. Sanjeev Kumar, our honorable principal sir. Swagat hai sir aapka. And we have with us Dr. Ashok Gogia, retired professor of geography and finance officer of Central University of Haryana. With us, sir, आपका भी बहुत स्वागत है. Now it's time to introduce our resource person for the first technical session. So we have with us Dr. Amit Kumar, assistant professor, Department of Chemistry, Central University of Haryana. He is an emerging chemical scientist with number of patents and research publications in reputed international journals. Speak volume about his serious engagement in research and innovations. His contribution in IQAC at Amity University and at Central University of Haryana has been quite significant and exemplary. Dr. Amit Kumar has worked very closely with our respected principal, sir, Dr. Sanjeev Kumar, in shaping the vision of an emerging Central University of Haryana. A very warm welcome to you, sir. By putting end to my words and for the enriching session on IPR, may I please request Dr. Amit Kumar to start his session.
Good morning to all of you. First of all, am I audible?
Yes, sir, you are very much audible. But kuch ek surround sound ki hai, if we can get rid of that.
So, thank you so very much, Dr. Priyanka, for introducing me for such a nice introduction.
Thank you, sir.
So, first of all, I extend my thanks to Professor Dr. Sanjeev Kumar, sir, for inviting me and giving me the opportunity to interact with the faculties and great personalities of the Mihir Bose PG College. So, without spending more time, now Sir has given me the duty to explain about the basics of intellectual property rights. And as Sir has already explained what are intellectual property rights and other things, so I'll discuss the basics of the intellectual property rights, aspects and prospects. So, with the permission of Dr. Sanjeev Kumar, sir, may I request you to please, may I share my screen and start the presentation. Is my screen is visible?
Nahi sir, abhi to nahi.
Yes sir, it's coming.
So, what are intellectual property rights, aspects and impacts? So, in this presentation, we will discuss about the basics of intellectual property rights. So, before discussing the intellectual property rights, first I want to discuss something about the knowledge. So, there are mainly two kinds of knowledge. One is academic research and another is industrial research. So, this is the little difference between academic research and industrial research. Academic research and industrial research. So, academic research involves the discovery of the fundamental knowledge that is useful for advancing the understanding of basic concepts, and the applied research, that is industrial research, involves two terms, that is invention and innovation, aviskar or navachar. So, industrial research is industrial research based on the applied knowledge that is useful to solve the wants, needs and challenges of mankind. So, from here, we all have learned that an idea can change the life. So, in today's world, where everything is depending on new technology, so every day we require the support of newer technologies. So, from where these newer technologies are coming, that we have to understand. So, these newer technologies are all coming from the ideas which a human being create, inculcate, protect and then commercialize them. So, the first step of the commercialization or first step for the preparation of any product is the idea. When idea came in your mind, what we do? We hypothesize, we create some hypothesis to prove our concept and idea. So, to prove our hypothesis, what we do? We do the series of experiments. So, from the series of experiments, what we find? We find the various results and we validate our idea on the basis of scientific findings. So, when we validate our idea, then what we find? We find the application of that idea. And if our idea is applicable to a useful application, then it comes under the category of invention. Then, if we find out the needs and opportunities, then it comes under the category of innovation. Means the invention which gives the solution of specific kind of need or opportunity comes under innovation. And if we find that our innovation is useful in solving the need of a particular kind, then what we do, we develop that idea, we develop that into a product, and we commercialize this. So commercialization of the products gives us wealth and values. So from hypothesis to commercialization, all the steps are covered, like discovery, invention, and innovation. So these are some of the steps which leads us into the commercialization of our idea. Then when we develop some idea, when we develop some products on the basis of our idea, then a term came intellectual property rights. Now there are three questions associated with this term, that is intellectual property right. First question is, what is IPR? This question is related to the aspect of this property. Then second is, who needs IPR, and then why does anyone needs IPR? These are the three basic questions associated with intellectual property rights. So we'll explore these three questions one by one. So this intellectual property rights, in intellectual property rights, if we see these three words differently, then they gives us four questions. First is, what is property? Then if we combine this property, if we have some property, so we have some rights with the property. Then the second is, what is property rights? Then third one is, what is intellectual property? And then fourth one is, what is intellectual property rights? So there are three words associated with this intellectual property rights. That is, what is property? Second is property rights. Third one is intellectual property, and fourth one is intellectual property rights. So what is property? We all know that properties refers to the tangible assets that are physical or financial in nature. We all have associated with some of the properties with us, like land, building, car, cash, etc. So all the tangible assets which have some physical or financial in nature are known as physical properties. Then we all know very well that what are property rights. If the property is on our name, then we have some rights on the properties, very clear rights. So property can be owned, property can be bought, sold, or rented out if the property is on our name. Property can be held for value appreciation. Property can be willed. Property can be used as collateral to generate capital or obtain a loan. Property values can be captured by the owner. So if we have some physical property, then all these rights are associated with the property. Then second question came, what is intellectual property? Unlike physical property, intellectual property also refers to a specific kind of intangible assets. This we cannot see, but these are the power of our ideas. So unlike physical properties, we have some intangible assets in form of intellectual property. Then there are three space of expertise and three dimensions of values of intellectual property rights. First is, if we create some technology on the basis of our intellects, that creates value creation. If we apply some laws to protect our intellectual property, so that we can do by the use of some laws. And if we use our idea to generate the wealth, so that comes under the business, means value creation and value capturing. So if we combine this value creation only in business, this gives us the technology with business. If we protect our technology with some laws, this will gives us the intellectual property with some specific laws. And when we combine the laws with business, this gives us the lawful business. And when we combine these all the three things, technology protected by laws and then convert into business, that will gives us the intellectual property rights. So these are the three space of expertise and three dimensions of the values of intellectual property rights. So there are three dimensions associated with intellectual property right. One is technology, second is law, and third is business. So combination of these three gives us intellectual property rights. So in the coming slides, we will understand what are intellectual property rights and from where these intellectual property rights originate. So what are the source of innovation of this intellectual property rights? This intellectual property rights as in the previous slide, we had discussed that research and development create or generate new ideas and new technologies. So technological innovations are associated with research and development. If we commercialize our developed product, then business model of innovation came into picture. And when we combine this technological innovation with business model and protected by some laws, this will gives us intellectual property rights. Then from where these intellectual properties came, there are two, as we had discussed, that everybody has a quest for knowledge. So if we have the will to generate or create some knowledge, then what we will do, we create some fundamental research. On the basis of the fundamental research, we do some discoveries. On the basis of discoveries, we develop some theories. And on the basis of the theories, we develop some models. So this flow, quest for knowledge, fundamental research, discovery, theories, and development of the model leads to the publication, journal publication, textbook and reviews, conference proceedings, and other some applications can be granted. So these are the academic based on the academic research. So these comes under fundamental research only. What generally we do in our laboratories, in our universities, in our colleges. But if we find the useful invention related to our discovery, and if we do the innovation, that gives us the value capturing of our fundamental research. So this is the academic flow of generation of the research. Second one is industrial research. In industrial research, we always see the business opportunities on the basis of unsolved needs, wants, and problems facing by the society. So this one comes under fundamental research, and this industrial research comes under creative applied research. So when the creative applied research, if we convert this creative applied research into useful invention and innovation, then there are two parts. One is on the basis of this invention and innovation, we do the publication. And second is, if we convert this invention and innovation into the valuable goods and services that will create or generate wealth to the inventor. So these are industrial research. So if we combine these both, industry, academia collaboration, then what we will find that the fundamental research which have the potential to solve the needs, wants, and problem of the society, and that can be commercialized. So on both the sides, we can solve the needs of the fundamental research as well as needs and wants of the society facing some problem. So if we focus on the applied research which solve the needs and problems of the society and can be commercialized. So it can be commercialized. So that creates wealth with academic fundamental knowledge. Now, what are intellectual property rights? So this generated knowledge, which is useful to solve the wants and needs of the society and which is commercialized. So how we can protect that? We know that we can protect our physical properties by various means. Like say we have a plot, so we have the registry on our name, so we can protect all the rights associated with that property with us. But the intellectual property which we generate through our idea, through our fundamental research, and convert that fundamental research into creative applied research and to solve the problems. So that also required protection. Otherwise, as Sir has explained, that in the today's world, it is very easy to steal the ideas of the ideas generated by one inventor. So it is very, very essential these days. If we want to commercialize our research, we have to protect our ideas or intellectual properties with some means. So there are various kind of intellectual property rights. Like in India, mainly 9 types of intellectual property rights are present, like intellectual property rights in terms of patents, trademark, trade secret, industrial designs, integrated circuits, geographical indicators, copyrights, plant varieties, traditional knowledge. Now, here I want to discuss one example. We all are very much aware the benefits of the turmeric, haldi, this हम कहते हैं, और we are using turmeric in various forms since ancient time, in food, in medicine, in healing wounds, and other various applications. So in 1995, what we feel from ancient, we have taught that knowledge is just for sharing. अगर हम नॉलेज का कमर्शलाइजेशन करते हैं तो वो नॉलेज नहीं रहती, हमें ऐसे सिखाया गया. बट इन टुडेज कॉम्पिटिटिव वर्ल्ड वी हैव टू प्रोटेक्ट आवर नॉलेज आल्सो, अदरवाइज the other peoples will take a benefit and may misuse that knowledge for other purpose. So one of the example is the patent of turmeric was granted by US Patent Office in 1995 to the 2 researchers. Then it came into the knowledge of Indian agencies, and we filed a very long case of more than 2 years, and we spent more than $15,000 US. And finally, the US Patent Office withdraw their patent, and they said, okay, this is the natural herb of the Indian origin. So all the rights will remain with India only. So like this, we have to protect our intellectual properties also. We have to protect our various properties from the others. So this now the first question came, that what are the patents? So patents are generally a set of exclusive rights granted by a state, means territorial rights, to an inventor or his as an assignee for a finite period of time in exchange for the disclosure of an invention. So patent, the history of patent is very ancient, not very recent. First designing patent was given to Floppy Bolonsky, which is an Italian artist, and for his discovery of for his industrial innovation in 1421. So he discovered a design which is used to transport the marbles, and he approaches to the government and he said, I want to protect my idea. So initially for 3 years, the government gives him the right. So this was the first origin of the history of the patent. Then the first Indian US patent was filed and issued in July 31, 1790. So we can see, if you want to go, there are links are given. So we can explore more about the first US patent, which is awarded in July 31st, 1790. So now the list of the Indian patents are long. Then in history, if we'll see in the history, in 1474, it came into the picture. Then Written patent status was established in ancient Greek in 1474. And if we talk in terms of Indian history of Indian patent, so on 3rd March 1856, civil engineer George Alfred was granted the Indian patent by the government of India for his invention, an efficient pankha pulling machine. So from here we can understand that what are patents, what are the mainly intellectual property rights. So what are patents, what are the histories of the patent, and from where the patents came. So we know that some rights are associated with these properties. So if rights are associated with these properties, we must have some fixed set of laws. So in Indian patent system, various acts are there. So first act of the Indian patent was framed and established in 1856, and thereafter various amendments were there. So if we compile these Indian laws in one slide, we will find that first Indian patent was established in 1970, then amended in 1999, then amended in 2002, then amended in 2005, then Copyright Act came into the picture in 1957, then further amended in 1999, then Trademark Act came in 1999, then Protection of Plant Variants and other these rights and acts, Indian acts came in 2001, 2099 and 2002, biological diversity. So then the second question came, what right does a patent award the inventors? If we apply for a patent and if patent is awarded to us, there are some special rights associated with the patents can be granted to the inventor. So right to prevent the invention from the others will lie with the patent inventor, then making, using, selling, offering for sale or importing the patented invention. So if you patent your idea, then you have the right to prevent it from the others, then you have all the rights of making, using, selling and offering the sale of that particular invention which you have patented. So it is very, very important to protect our idea that we have to first get the patent. So then what are patentable inventions? Then second question came that what are patentable inventions? So we can patent any process, we can patent any machine or device, we can patent article of manufacturing also, we can patent composition of the material, we can patent improvement or new use of the existing product or any process like machine, device, process, composition, any kind of thing we can patent. So if anything innovative or anything new you develop, you can patent, which has the commercial value. So by protecting your idea through patents, you can generate wealth. If you not patent, if the rights are not with you, then anybody or anyone can take the advantages of that. Like it is very simple example. If we associate that with our physical property, we'll understand. So if we purchase some land and if we'll not do the registry, then the rights will not lie with the buyer. The rights will lie with the seller only. So he can do anything, whatever he wants with that property. So to protect our, similarly like physical property, to protect our intellectual property, we have to take the rights of that intellectual property which we generate from ourselves. So these kind of patentable inventions also, so subject matters are there. So examples of the process. What kind of process we can patent? We can patent the method of making of anything like drug, or method of using like software applications, method of controlling anything like factory and other things, method of doing. Like so if some innovation technology patenting came into our mind, then we feel that no, this is the just area of science. No other can do the invention or innovation. No. So intellectual property right means the intellect which you have in your brain. So the idea or the things which you generate from your intellect can be patented, or of any kind. So example of this the process examples of process are any kind of processes of making drug, making food, making cold drink, making pizza, burger, any kind of process you can patent. Second type of example is making of machine or a device. Like if you'll see, the first telegraph was patented in US and protected the design. If you want to go into the detail, the links are given below. I'll share these slides. So one I'll show you one patent. First one is 1647. So we can make the we can protect our machine as well as the device. No, this one. I'll show you. So example of machine. So first like telegraph, telephone, electric bulb, electric laser. So these are the examples of the device or machine. So these are the examples of process patent. What kind of process we can patent? What kind of machine? Any kind of machine which have the commercial application can be patented. So design of the machine or device can also be patented. Now this is one example I'll show you. This is the combination of process, product and application which we have patented in 2018. So I'll show you this for reference. So in this patent, what we did is we patent the process, we patent the product, and we patent the application. Is my screen is visible?
Yes, sir.
Okay, wait. So in this patent, what we do is we protect the three things. One is process, we protect, then we protect product, and then we protect the application also. Yeah, this one. So in this, what we did is lithium metal quinolates and process of preparation thereof. So we protect the process of the preparation of lithium metal quinolates, which was the existing process. We simplify that process and protect that process. Second is we protect the positions and other alkyl groups. So we protect the products and we use these materials into the device for a practical application. So in the single patent, we protected three things: process, product, and material.
Not audible. Amit sir, your connection is not very strong. And
Yeah, maybe there is poor connection, so we should wait for some time. Surya ji, let's be patient and
We
wait
can
for some time.
also we can also patent the composition of the metal, like in mechanical mixing garam masala product we have कि आप कहते हैं ना कि this is patented formula कि इसमें this masala is very tasty. So what is the formula of that? If we patent that formula, if we patent that taste, so we can patent the composition, so that we can patent that we can protect the taste, or we can protect others to make that develop that taste by using those materials. Then we can also patent the chemical composition of matter in chemical mixtures also. Like there are various kind of chemical products are available in the market. So if you want to produce some specific kind of product, so what you have to do, you have to patent the chemical composition of that particular product. So like in surf excel or surf, various kind of products are there, like surfactant, binders, bleaches, enzymes, corrosion inhibitor, perfumes, etc. So we can also patent the chemical composition. Then what is the term of protection of the patent? For how many times we can protect our idea, we can protect our intellectual property. So the intellectual property in terms of patent can be protected for 20 years from the date of its filing. So up to now, what we had discussed the patent, what are rights does the patent awards the inventor, what are patentable inventions, and terms of the protection of the patent. So I think we have heard many times in our daily life also कि अगर हम कोई चीज किसी को नहीं बताते हैं तो पूछते हैं कि क्या ये आपकी पेटेंटेड आइटम थोड़ी ना है आपका कि हम इसको नहीं कर सकते. It means if we protect our intellectual property with some laws that gives us specific exclusive rights for its use, sale, purchase, and production. So the idea which we feel that this idea has commercial value, so we should patent our idea so that we can generate the wealth from that particular idea. So how we can protect? We can protect our ideas with some laws. So those laws are known as patent laws. So we'll not go into the detail of those patent laws. How we can draft the patent, how we can file the patent. Those are other processes. So here we will just discuss about what kind of intellectual properties comes into the category of intellectual properties. So the second kind of intellectual property is like copyrights. So I think Santosh sir will discuss more about copyrights in the coming session. So copyright is the form of protection of authors of original work, such as literary, dramatic, musical, artistic, and creation other than intellectual work. So all these kind of works comes under copyrights. So then what type of works are copyright protected? So any kind of work which is published or unpublished, it covers under copyright protection. So copyright protection is available to both kind of published as well as unpublished work. Third one is, how does copyright protects our work? Generally, copyright protection arises automatically as soon as an original work is fixed in a tangible form. So if we write our idea, if we write our manuscript, automatically it comes under the process of copyright protection. Then, how does copyright works? The copyright in the work of the authorship becomes immediately the property of that particular author who created the work. So, as I discussed, the more will be discussed in the coming session by Santosh sir. Then, what are the exclusive rights of a copyright? So, the copyright gives the copyright owner to the owners the following 5 rights. One is reproduction right, another one is adaptation right, third one is public distribution rights, fourth one is public performance rights, and fifth one is public display rights. So these are 5 exclusive rights to do, authorize others to do the following things. So if you generate your any copyright material, so immediately these 5 copyright rights will lies with you only. Then term of the protection of the copyright. The term of the protection of copyright is little larger in comparison to the patent. So the term of the protection for copyright works for lifetime plus 60 years after the death of the author. So for a single author, that will be life plus 60 years. Then third kind of intellectual property rights is fundamental this trademark. We all are very much aware about the symbols of any company. So trademark is generally a sign or combination of sign used to identify or distinguish the goods or services of one seller provided from those of the others. Like we have seen various symbols like Coca-Cola symbol, Pepsi symbol, Dew symbol, Mint symbol, Aquafina symbol, and various like this Wipro symbol, Infosys symbol. So these all comes under trademark. So trademark is a sign or combination of signs which generally distinguish or differentiate, or means these are the identification marks of the services or goods which one provide to the others. So examples of trademarks, there are various examples of trademarks in our daily life. If we'll see around us also, we'll have various trademark symbols. Like if you have the trademarks, examples of trademarks are in form of letters and abbreviations like McDonald's, GE, IBM, etc. These are trademarks in form of letters or abbreviations. Trademarks in terms of logos or symbols like Maruti Suzuki, Apple, like IBM, BMW, Toyota. Trademarks in terms of picture and drawings, trademarks in terms of logos and words also. So in terms of words and number also, like Boeing 747, Levis 501. So these are some of the examples of trademarks. Some other examples of trademarks are also there, like slogan also we can trademark, letters and slogans, combination we can also trademarks like GE, image and advert. Words, shapes and colors can also be trademarked. Then product shape can also be trademarked. Then sound marks also can be trademarks. For more, you can go to this link regarding trademarks. So now the question came, the terms of protection of trademark. So trademark registration, if you create some trademark for your company to distinguish your work or your product or your supply with the others, what you have to register your trademark. So trademark is the specific or distinct signal which you put on your product, which distinguish your product from the others. So this registration protect your trademark for the period of 10 years from the date of its application, and then subsequently you can renew your trademark by each time for period of further 10 years. Then trade secret. So these are the secrets which has commercial value. Means what are trade secrets? So trade secret is the information which has commercial value and then need to be kept constant. So the commercial value secret, the commercial value which the value which has the commercial in nature and need to be secreted. Let's say we are very much aware that we must have seen, I think, the movie जिसमें बताया गया कि Pepsi never disclose their formula. So that the formula of that Pepsi is the comes under trade secret. So if we take the example of one trade secret, you'll see the Coca-Cola formula. It is the information which has the economic value. Lot of economic value is there in that formula. So it should be top secret. So Coca-Cola kept this the formula in a locker in a bank that is in USA, Atlanta. So if you want to see that trade secret, what you have to do, you have to pay the value decided by the company. So these are the informations which has commercial value are known as trade secret. So to protect our formula from the others, we have to keep them secret. So these kind of values are known as trade secrets. Then industrial design, geographical indicators, and traditional knowledge. These are also comes under intellectual property right. So another form of intellectual property rights is industrial design. So industrial design, if you create some industrial design, that can be protected under the Design Act 2000. So as the name indicate, any design which has industrial application. So it can be a shape, it can be a configuration, it can be a pattern, or it can be a composition of lines or colors, or that can be applied for the manufacturing or fixing some industrial product. So these designs comes under industrial design intellectual property rights. So this Design Act 2000 capable of being the products for industrial application, that these can be protected in form of manual, in form of chemical, in form of combined, separate or combined. Then this Patent Design Act 2000 also not be mere mechanical, applied for mere mechanical device. It can be applied for the mode and principle of construction also. But for industrial design, what we have to do is the design must be new or original. So original means it should be different from the others, and originated by the authors or the designer. Or it should also have some newer application. Then what are the terms of industrial design? Industrial design has the terms initially for 10 years from the date of its registration plus 5-year extension every time. Then this is very, very interesting and important intellectual property. That is geographical indicators. We know, generally सुनते हैं, there are various products which are associated with the geographical locations like origin of goods, quality, reputation, characteristics are very associated with a specific geographical location. Generally हम कहते हैं आगरे का पेठा, नासिक के अनार. So these are some geographical indicators which indicates that अगर आगरे का पेठा है तो उसकी ये quality होंगी, इसकी वो reputation है, एक characteristic है. So that also we can protect. But like intellectual property, inventor can protect, geographical indicators cannot be protected by individually. That can be protected by the societies. So and these comes under Geographical Indicators Protection Act. So for geographical indicators protection, we can protect these geographical indicators initially for 10 years, and then that can be renewed for a regular interval of time. So I'll show you one two examples of the geographical indicators, means intellectual properties in terms of geographical indicators. Just wait for a second. Yes, this one. This one. See, you can see these geographical indicators. यहाँ आपने देखा application number is 223. Geographical indicator is Agra Petha. Then applicant name is Petha Laghu Udyog Samiti. So if you'll see that a patent comes under a patent can be awarded to the inventor, but these geographical indicators can be awarded to the societies. So and the person who are working in that particular area has to register himself and herself under that particular society. So these also comes under the intellectual property rights. So IPR also has the commercial value of the geographical indicators. So this is one of the example. There are other examples also, like Nasik Canal and other things. So these all comes under geographical indicators. Then traditional knowledge. Traditional knowledge is the inherent knowledge or which flows generally from generation to generation. So like cultural knowledge, environmental knowledge, medicinal knowledge also comes under intellectual property rights. Then in order to sum up, who needs intellectual property rights and why we need intellectual property rights? We, as we had discussed, that every idea has their commercial value. So if we generate or develop some idea, and if we want to make money from that idea, then we need intellectual property rights. We need rights to reproduce or to do business on that particular idea. So innovative startups as well as established companies. So the companies, those who are doing business, whether they are small scale industry, middle scale industry or large scale industry, if they require sustainable growth and strategic competitive advantage, they need IPR. Here the terms came, sustainable growth and strategic competitive advantages need IPR. बाकी अगर हम अपने घर में कुछ बना के कुछ लोकल में बेचते रहें जिसका कोई वो नहीं है तो उसमें that we do not require IPR. But if we want to go global, then if we need strategic growth, if we need strategic competitive advantages, then we need IPR. There was a case in between Samsung and Apple company, and I think I don't know Samsung I think infringed some patent rights of the Apple company, and they have to pay a huge amount to that particular company. So for sustainable growth and strategic competitive advantages, we need intellectual property rights. I'll give you one example, very simple example, how these very, very small, simple example can generate a very good wealth if we take the patent of that. Like this, we all are very much aware about this ring pull cane, ring pull can. So this is licenses to the license of this ring pull opener was given to Coca-Cola for a fixed term. And what was that wealth? They said, okay, you gives us just 1/10 penny of per can on per can. And you will be surprised to know that during the period of the validity of that particular patent, the inventor receives 1,48,000 UK pound per day as a royalty. So from this, you can imagine that how important is to protect our idea, how important is to protect our intellectual property. We'll discuss that because the value of intellectual property is very difficult to assess. Physical property we can assess, but the value of intellectual property is very difficult to assess. So it is very, very important to protect our intellectual properties. Then, why does anyone need intellectual property? One example we had discussed, that why inventors need intellectual property rights, we had discussed. But with one example, I take this figure from this book, that is Intellectual Aspects for Engineers and Scientists, Creation and Management by Uday S. Rasela. In this, he explained that, as we had discussed, there are three things. One is invention, strategy, and intellectual property rights. So, why we need invention and strategy? Gives us strategic innovation. Invention with IPR gives us non-strategic innovations. Strategy with IPR gives us strategic IPRs. But all the three things combined together, so this area you'll find strategic innovations and IPR protected. So USR model of strategic innovations and IPR says if we combine both the three things, strategy, innovations and IPR, then our innovation will be strategic innovation with IPR protected. So for sustainable growth and for competitive growth, we need IPR protection on our strategic innovations. So in conclusion, if we'll see that मोटे-मोटे terms में अगर हम देखना चाहें, so what are generally intellectual properties? Intellectual properties are well defined, different forms. The various type of rights are there. Well defined different forms of intellectual properties are there. Then on physical property, different type of rights are there on the physical property. Valuation of the intellectual property is not easy, but valuation of the physical property is comparatively easy. Theft. If you have the physical property on your name, it is very difficult to theft that property by the others. But if you have some intellectual property and if you do not have any written right on that property, so anybody can theft it very easily. So like the example which we have given, that in our ancient time we were having all the important things. और हमें कब लगता है? हमें जब लगता है, जब तक हमें नहीं लगता तब तक हमें उसकी जरूरत नहीं होती, क्योंकि हम ये मानते थे कि हमें किसी भी चीज को, वैल्यू को, नॉलेज को कमर्शियलाइज करना ही नहीं है. If we commercialize the knowledge means वो चली जाएगी, लेकिन we have to protect our that knowledge also from the others. Otherwise, other will misuse that. So the effect on time, if we'll see the effect of time on the intellectual property, usually the value of the intellectual property is decreased with time and ends up after some time, but the value of the physical property generally increases or decreases depending upon the type of the property. Say we have land, so the value may increase. Say we have car in form of physical property, the value may decrease. But from this, what we have concluded, that we need, like our physical property, we need to protect our intellectual properties. And if we develop or generate some intellectual property, we have some rights associated with that properties, and with the help of some rights, we can protect our intellectual properties also, and we can commercialize and do some business with the help of that intellectual properties. So I think these are all about what are intellectual property rights, what are different kind of intellectual property rights. I tried to cover with examples. I think thank you so very much for the patience listening, and thank you so very much Professor Sanjeev sir and MBPG College for giving me the opportunity. So these are some of the links. If you want to explore more about all these are the links, like US Patent and Trademark Office, Indian Patent and Trademark Office, History of Indian Patent, History of Patent, World Intellectual Property Office, European Patent Office, and others. So this is also the book which explained very well about the creation and management of the intellectual property and its aspects for various scientists and engineers. So, and you can see that everything is given on this website. This is patent, design, trademark, geographical indicators, and various other informations are given on this tab. So, thank you so very much, sir. So now, if we can discuss.
Yeah, somebody should raise some question, or of course some observations should be shared.
Yes, sir. I have one question.
Yes, madam.
Sir, first I would like to thank you for giving us such a valuable insight. Sir, I have one question. Sir, how much time it takes in filing the patent and getting it?
Previously, it takes a lot of time, like years. But now these days, this application process is very fast. So in few months or within a year, you can get a patent.
Sir, since I have filed one of my patent in 2013 and it is still under process, I haven't get it, and they have just sent some queries like about its novelty and other things, but it is still under process. Since
There
at that
are
time I was doing PhD and I was working with my PhD supervisor, and he is the primary applicant of that. So I
right.
can't talk to that person directly, and they have taken so much money. Also, I think it's approximately near about 1 lakh they have taken.
Right,
So
right, right,
so
right. मैडम इसमें ना दो तीन चीजें हैं देखिए एक तो लाइक द पेटेंट विच आई वाज शोइंग टू यू वाज यूएस पेटेंट विच वी फाइल्ड इन 2012 and we got that patent in 2018. Like similarly, the Indian patent which we filed in 2015, we got that patent in 2017. So in 2 years only we get that. So दो चीजें हैं, एक तो इंडिविजुअल पेटेंट अगर हम फाइल करते हैं तो जनरली हम उसका फॉलो अप जल्दी लेते हैं. So there are various stages filing.
Yes, sir.
There are various stages of the granting of the patent. So we'll
Yeah.
discuss that also in some other day, patenting process. So इसमें जैसे हमारा है patent filing, then its publication, then its evaluation, then query clearation, then protection of those claims which you have explained in your that. So there are various legal issues also associated with these. So sometimes they takes more time, but if we'll do the regular follow up, so we can expedite that process also.
Yes,
That's why
because
इसमें दो चीजें होती है मैडम. इसमें ना
Yes, sir.
filing individually patent filing is very difficult because fees and sometimes protection fees is also very high. So always we are associated with some of the institution. Say for example, we are associated with Mihir Bhas PG college. So the assignee will be the college. And the government will pay the fees because that for generating the intellectual property, they are giving you the money in form of our salary and all the facilities.
and yes, sir. After that, they will share all royalty also. After if I will get patent, they will share royalty. And if I am individual assignee, then I will not share my
Right.
Yeah. Yes, sir. Okay, sir. Okay, sir. Thank you so much.
Thank you so much.
Yeah, some of the scholars are also there. You may please share your observations.
Sir, 2-3 queries.
Yeah, sir, please.
Let the first one be related to this patent thing. If a product is patented,
Right, sir.
what is the use of patenting the process?
Right, very good question, sir. Sir, say if that's why we generally go for the product patent. कि अगर suppose हमने initially if the product patent is not there and if only process patent is there, then we can improve that process. But we generally go for the product patent. Say for example paracetamol, सर आप example लीजिए. Paracetamol A, B, C, D, E 4 methods से बनता है. And I protected method A for the preparation of paracetamol. But you will develop another method for the preparation of paracetamol, and there is no use of my process. But if
No, my point is,
that's why we should go for the product patent.
Protecting a process for an unprotected product,
It's okay. Yes, sir. But for protected,
if
then there is
itself is protected, say for 10 years, then there is no use of.
Then there is no use of the
process for 10 years.
Right, sir. No use. We should go for the product only.
Because you said that in some of your patent you protected, I think 3 things.
I protected product and process for some of the unprotected products.
Sir, you lost your connection perhaps.
And applications of the products. All the 3 things we have patented in our product, our patent.
If you say product is enough to start with, then it is, I don't find the words overzealous or something that you are
Right, sir. Right.
Another thing is, sir, it is not related to this, but this basic research and industrial research are absolutely different things, or one is dependent on another.
Industrial research always comes from basic research, sir.
That's the point, but you seem to be suggesting as if the very different thing, and we should focus on industrial research more.
No, sir.
This only when we have some basic research.
Yes. So basic research is the research which generates some understanding.
Yes.
But on the basis of understanding, we should commercialize that research for the product. So if we'll commercialize that for a product, so that will give us wealth. So always industrial research comes from basic research.
Yes.
So first we require academic excellence. If we'll have the academic excellence, then only industrial excellence will come into the picture. So for growth, we need industrial excellence.
Yes. I got the point, sir. And now the very light question on very light note. You take it the way you want. Why do we call it research? Why don't we call it search?
Actually, what I feel, sir, you all are very good intellectual people are sitting here. What I feel that everything is happening in the universe. This universe is in balance, so every process is going on. So what we want to do, we have to research the explanations.
Oh, very good answer, sir. Very good. I have never thought of it. I just keep on pondering over it. Research is accidental thing, is part byproduct of research.
Right, sir.
But we keep on saying research.
Right, sir. I'll give you one example. Just say Archimedes ne principle diya. So Archimedes went for the bath. और जैसे ही वो bathtub में गया, पानी बाहर आया. So every day the process was going on. Daily हो रहा था. But उस दिन उस mind में आया, and then he give the explanation of that product, that process. कि अपने mass के बराबर पानी बाहर निकलता है. So हो रहा था वो, because we are in the universe where the things are happening every day, and we all are like observing the things. But just we are giving the explanation that why the things are happening and how the things are happening. And what I understood that, sir, कि जिस चीज का हम एक्सप्लेनेशन नहीं ढूंढ पाए हैं अभी तक या नहीं ढूंढ पाते हैं, हम उसको सुपर नेचुरल पावर से एसोसिएट कर देते हैं फॉर सिंपल एक्सप्लेनेशन. So many examples are there for giving the explanation. और जब हम उसका लेकिन अगर हम उसमें भी जाते हैं, so because the process is happening in the nature, and the nature is all associated with all following all the natural laws, and all the natural laws are means scientific laws.
Actually, yes.
Because everything's are balanced because of the scientific laws, and just what we are doing, we are just giving the explanation of those happenings.
Thank you, sir. Thank you making such a beautiful explanation. I was just searching for. It was not so much of related thing. That's why I said it is unrelated.
Thank you so much.
So Harsha,
some of the scholars should also share their observation, please.
Sir, I want to ask one thing. If this patent process is taking so much of time, then what is its, application relevance? It's a wastage of 10 years and more, and I cannot publish that paper that is related to that patent process. So, how come it's very relevant to this society? I mean, how I am giving any, useful thing to society, because taking 10 years.
We need to, for this, what I feel is we need to expedite the patenting process only. So we all have to work in the way so that फटाफट से हमें patent मिले, और जैसे ही idea आता है, we should protect our idea. And government agencies also, but recently the patenting process has becomes very fast. I was discussing with one of my colleague, and they got patent within 3 months only. Within 3 months they got the patent.
Please tell me about that. I mean, after some time, whenever you get time, please tell me about that process.
Okay.
How can I go to? Yes, sir. Okay, sir. Thank you so much, sir. Thank you so much.
Thank you.
Yes, scholars, please.
Thank you so much, sir, for such a detailed presentation. We find ourselves fortunate that we got the opportunity to learn about intellectual property rights from you. You yourself have been awarded with 3 patents, 3 others have been published, and you have also got 64 publications in reputed international journals to your credit, sir. Thank you so much for this presentation, sir.
Thank you so much, sir. This is all one thing I want to explain. This is all because of the inspirations of Professor Sanjeev sir. Sanjeev sir is always a role model for us, actually, source of inspiration for us. Thank you so much, sir.
Thank you, Amit sir.